David Clendon.
I'd just like to speak to one specific point, which is new clause 36A, and in particular 36A4. So the Select Committee, the majority report from the committee, indicated that there should be a new clause 36A, which, and I quote, "we hope will ease the Attorney-General's concerns." We all want our Attorney-General to sleep well at night. The specific concerns expressed by the Attorney-General were in respect of the lifelong reporting obligations that can be imposed on people who are captured under this bill. The Attorney-General deemed that this was inconsistent with Section 9 of the Human Rights, of the Bill of Rights rather, which is the right not to be subjected to disproportionately severe treatment or punishment. And the Attorney-General said he considered that registration and reporting obligations constitute a punishment. So after a person has been tried, convicted, sentenced, completed a sentence, nevertheless we're going to impose further punishment on them. He suggested that placing registrable offenders on a register was not in itself disproportionate, but the fact that in the original drafting of the bill there was no mechanism ever for a person to have the name removed from that register. So 36A does address that. I should say that similar concerns were expressed by the Human Rights Commission, who said that, and again I quote, that lifelong registration, which may be invoked retrospectively and without the possibility of independent review, constitutes disproportionately severe treatment. So two fairly high-powered comments there that we really ought to have some means for people to extract themselves from this register. Section 36A was inserted for that reason, but unfortunately what it does, and 36A4, I quote, "The court may make an order indefinitely suspending the reporting obligations of the offender only if the offender satisfies the court that he or she does not pose a risk to the lives or sexual safety of one or more children or of children generally." In other words, it's a reverse onus of proof. It's incumbent on an individual to prove their innocence rather than for corrections or police or anybody else to demonstrate there is an ongoing serious risk. That's an unfortunate wording. It's an unfortunate, as I say, reversal of the usual expectation that the prosecuting body, if you like, in this case the police, the corrections, whoever, would not be obliged to prove that a particular individual continues to represent significant risk to children, but rather the onus is on the individual to prove their innocence. And I think that's back to front. I don't think that's appropriate at all. It does say that the police and corrections may make submission. If a person applies, I should make the point, they may not make such application until at least 15 years have gone by, at which point, if they are unsuccessful in their obligation, in the normal course of events, they must wait at least another 5 years before they can make a similar application. It just seems to me wrong, sir, that a person who has not offended or reoffended for a period of 15 years after release from prison, nevertheless is obliged to demonstrate innocence. And I really wonder, how can you do that? How can any of us prove to the satisfaction of a court that tomorrow we're not going to go out and offend in some way, large or small? I find it difficult to think of how one would construct such an argument. An argument of innocence against the charge that you're guilty is one thing, but proof of innocence, I think, sets too high a bar, and to me is most unlikely, in fact, to satisfy the concerns expressed by the Attorney-General or indeed by the Human Rights Commission. Thank you, Mr Chair. I'll leave it there.
Mr Chair.
I call the Honourable Anne Tolley.